Good morning.
Just go around there, just mind the court and just take a seat. Okay, I'll go.
We'll just wait for one moment while everybody pops in, and then we'll get cracking.
Through the chair, I'm obviously IT challenged.
Even with the flash headphones.
The headphones aren't the problem.
Kia ora koutou, good morning everybody. Welcome to hearing 14, Historic Heritage and Notable Trees. As you will appreciate, this is a Zoom hearing, which is a little different from what you might be used to for those of you that have been involved in hearings previously. What I can say though is that the panel is now onto its 5th or 6th one of these, and we're pretty satisfied that it works quite efficiently and that we get to hear what people want to tell us, and we can ask them questions in a fairly straightforward and user-friendly way. For those of you that are new to either hearings or to Zoom, we will be as informal as possible, respecting the fact that we are in a semi-formal place, so we would just ask people to be respectful of other people's views and all those sorts of things that would normally be expected to apply. I'll run through a few of the procedural matters of how we'll run today in a moment, but I will firstly just ask everybody to introduce themselves briefly, starting with the panel. And I guess I should start with myself. My name is Phil Mitchell. I'm chairing these hearings, and I've been a resource management planner and hearings commissioner for quite a number of years now. So I'll just ask the panel to introduce themselves, and then we'll work around the rest of the virtual room, please.
Morena koutou, my name is Will Marg.
I'll go next. Kia ora koutou, I'm Linda Tiaho and I'm one of the commissioners.
Morena, everybody. I'm Janet Gibb. I'm a councillor for the Waikato District Council and a commissioner for approximately 5 years.
Thanks, that's the panel. Maybe we just do the staff, council folk next, and then we'll whip around the rest of the people.
Good morning, my name's Alice Morris. I'm the author of the Section 42A report.
Morning, Ms. Morris.
Hi, I'm Bronwyn Kassouf, but I'm just here in a capacity just to listen to this Block 1 hearing. We're in the next block, Block 2.
Thank you.
Can you just hop in?
Yeah.
Morena, I'm Carolyn Ratt. I am a planner and assisting Waikato District Council.
Morena, I'm Betty Connolly. I'm a senior planner here at Waikato District Council and assisting Alice Morris.
The musical chairs going on there, by the way.
Good morning, Grant Searle, Waikato District Council, arborist, representing council and helping out Alice.
Thank you.
Kia ora koutou, Anne McEwen. I'm the heritage expert for council.
Good morning, I'm Kevin Gordon, district arborist, assisting with the review.
Thank you. I think just as this musical chairs thing, here comes Ms. Parr. I'll wait for her to introduce herself, and then we might just make a couple of suggestions, I think.
Morning, Bridget Parham, Councillor for Waikato District Council, just assisting the council team.
Morena, I'm Fletcher Bell, and I'm just the District Plan Administrator for the Waikato District Council. Thank you.
And this is Mr. Bell's first hearing, so we would respectfully ask everybody to be especially nice to him so he doesn't get scared off on the appearance. Could I suggest that the council folk that are in that room swivel the camera around or something? This musical chairs thing's going to be really distracting every time someone wants to say anything.
We can just swivel around.
Yeah.
I think that's going to be a lot more helpful to us, please.
Sounds good.
Thank you.
I think we could also mute this one and unmute that one.
When we need to, yeah, we'll just have to coordinate that really well there.
Okay.
Now I think we'll perhaps move to the submitters, please. I think there's 3 ladies all sitting in the council office. Perhaps if you could introduce yourselves one by one, please.
Morena, good morning. Jenny Kelly, Waikato resident and ratepayer.
Good morning, Ms. Kelly.
Morena, Kathy Miller. I'm the Vice President of the Residents and Ratepayers Association of Rangiriri. I'm also a owner of business property in Rangiriri.
Thank you.
I'm Christine Madsen. I own the Rangiriri Heritage Centre. I'm a ratepayer and I also live in Waikato.
Thank you, Ms. Madsen. We've heard from Mrs. Kusoff. Mr. Wood, I think you might be second to last.
Good morning, my name's Brendan Wood. I'm here just to make submissions on my property.
Thanks, Mr. Wood. Ms. Pico?
Hi, it's Will Gauntlet here. I'm not sure if my mic's working. I'm observing today. I work for the Waikato District Council, and I understand Cheryl Pico is observing also.
Okay, she's on silent. We've got a nice picture of her ceiling light by the look of things. So that's all good. We've also got someone, Isabel, present. Could you just introduce yourself, please, so we know who it is that we're talking to, please?
Yes, Morena, Isabel Hope. I'm part of the committee of the Tiuku Hall in Tiuku.
Thank you very much. All right, well, thanks everybody. I know that's been a bit of a laborious start, but we just wanted to make sure everybody was aware of who everybody in the room was. Just in terms of the way that we organise today, I think there's a couple of things that we want to stress before we start. The first one is that we have read all the written material that's been pre-circulated and which has been available on the council website. That includes all the evidence, all the council reports, and where submitters haven't actually lodged any written evidence, we have read their formal submissions that they have lodged when the plan was notified, together with their further submissions. So the way that we organise these hearings is for all that material to be taken as read, and unless submitters have sought leave for longer time, we're anticipating that they spend no more than 10 minutes summarising the key points that they want to emphasise to us by cross-referencing their evidence if they wish, but it's of pretty limited value to everybody to read out vast chunks of material that everybody's already pre-read. So we're very keen to get to the nitty-gritty of what it is that's of concern to people so that we can really get to grips with that in a fairly efficient sort of a way. We start the process with the council presenting their what's called their section 42A report. That's the report that sets out the background to the plan change, their evaluation of the submissions, and their recommendations to us. And in this case, the council's assisted by a number of specialists that have contributed to that process. I don't think we're necessarily expecting to hear from each of them personally, but we don't limit the council presentation to 10 minutes because unlike the submitters that are here who are dealing with one topic each, if you like, they've got to deal with the whole plan. But the same rules of engagement apply in that we're expecting them to summarise key points of difference, key conclusions and key recommendations rather than to take us laboriously through each and every paragraph of what's a very substantive document. We then move on to the submitters, where we hear from them one by one. And again, we request people to stick to approximately a 10-minute time frame, please. At the end of each submitter's presentation, the panel may ask some questions of clarification. We're not there to interrogate anybody, or, you know, for those of you that have watched LA Law or Perry Mason or all those sorts of things, that's not the purpose of today. The purpose of today is simply for us to clarify anything that we're unsure of, so that when we go away and deliberate to make our decisions, we're in no doubt what it is that folk have told us and what it is that folk are seeking to achieve via their submission. We'll have a break at approximately 10:30, and that will mean that everyone will need to log off when we do break from this Zoom meeting and re-log on via a separate meeting request that you will have all been sent. Whether you choose to be involved in a session that doesn't involve you if you're on before morning tea is entirely over to you, and we'll just leave that to everybody's discretion. The hearing is public insofar as anybody that wishes to is able to observe, and I'd simply note too that we, as you will have heard at the start, the proceedings are recorded. They're recorded both visually and they're also recorded orally, and both of those recordings will be available on the council website for those that want to look at them at some later date. I should also note that we've received a letter from the Ministry of Education and a letter from the Waikato Regional Council that they've asked to be tabled, which we will do. We've read that, but because nobody here is particularly involved in what it is they have to say, they've simply recorded their support or not for several of the provisions in the report that's been prepared by Ms. Morris. But we will note that they've been tabled and take that no further in the formal hearing today, although we will consider it. So before we press on, I just wanted to check if there's any questions that anybody wants to ask relating to the proceedings. Sounds like there isn't. What we would ask too, sorry, just by way of one final thing, is that if you are a submitter and it's not your turn to talk, it would be helpful to mute your sound, just because it does tend to echo around and magnify itself, and it can be fairly distracting. So if you aren't physically speaking, or if you're not one of the panel, it would be helpful if you could mute your sound. And I just note, Mr. Wood, you're probably, I think, about the only one that hasn't done that at the moment, but you now have. So thank you for that. All right, without further ado then, I think we'll kick off with the presentation of the Section 42A report. Thank you, and I think we'll start with you, Ms. Morris.
Thank you, Chair. I have prepared an opening statement to introduce and talk about the Section 42A report, the submissions, evidence, and Council's rebuttal. So I will just, I understand that the panel has got a copy of my opening statement. So I will just read through point 1 and 2, and then I'd like to take points 3 to 9, sorry, as read. So my full name is Alice Jane Morris. I am the writer of the 42A report for Hearing 14 of Historic Heritage and Notable Trees, and I'm the author of the rebuttal evidence in relation to this topic. I am a principal planner in the City Planning Unit at Hamilton City Council. And Hamilton City Council is giving Waikato District Council assistance where the City Council staff can provide certain expertise, and this is one of those cases. I'd like to take my qualifications, code of conduct, and conflict of interest as read. Is that acceptable?
Yeah, that's fine, thank you.
Okay. Paragraph 10, preparation of the 42A report. The scope of the 42A report was to evaluate submissions and further submissions received in relation to the provisions relating to historic heritage and notable trees. In preparing the Section 42A report and for technical matters at this hearing, I rely on expert advice from Dr. Anne McEwen, Heritage Consultancy Services on historic heritage matters, and Mr. Grant Searle and Mr. Kevin Gordon, Waikato District Council arborists relating to all of the noble tree matters. I do not intend to cover my recommendations in detail, set out in either the 42A report or the rebuttal evidence. My opening statement will provide a broad overview on the planning framework of the protection of historic heritage and noble trees, an overview of the submissions and the main themes from those submissions, summary of recommended amendments, and matters of contention raised in submitter evidence. I'm now on page 4, the planning framework of the protection of historic heritage and notable trees. Statutorily, historic heritage is a matter of national importance. The legislative protection for the retention and management of identified historic heritage is addressed via 2 statutes, the Heritage New Zealand Poiatonga Act 2014 and the Resource Management Act 1991. The purpose of the Heritage New Zealand Poiatonga Act is to promote the identification, protection, preservation and conservation of the historical and cultural heritage of New Zealand. The Act provides the statutory direction for Heritage New Zealand Poiatonga, who administers the New Zealand Heritage List, regulates the protection of archaeological sites and provides management of heritage in ways such as heritage covenants. Heritage New Zealand, which I will refer to them now in terms of short, with the exception of regulating the protection of archaeological and pre-1900 sites, has an advocacy role in the protection of historic heritage. The Resource Management Act identifies historic heritage as a matter of national importance. Regional and territorial councils are required to ensure the historic heritage of their respective jurisdiction is protected. Heritage protection is achieved by promoting the sustainable management of this physical resource, and an absence of protection leaves the heritage items vulnerable to demolition or deterioration, and therefore not sustained for future generations. The protection of built heritage and post-1900 sites is totally reliant on how territorial authorities schedule the protection of identified buildings, items and sites in their district plan. The National Planning Standards seek to provide a standard format for district plans across the country. The management of historical and cultural values under the direction of the National Planning Standards is for all relevant provisions to be contained in identified chapters within this section of the district plan headed Part 2, District-Wide Matters, Historical and Cultural Values. Now, I haven't stated here, but the framework of the existing proposed district plan for the heritage protection could achieve the National Planning Standards intentions. Historical heritage in the Waikato District. Paragraph 17. The Waikato is a source of rich history in terms of the growth of New Zealand as a nation. The management of historic heritage in the Waikato region cascades from the Waikato Regional Policy Statement, Policy 10.1, Historic Heritage, which provides direction on the management of Waikato's historic heritage. Specifically, the collaborative, consistent and integrated management of historic and cultural heritage resources for the region. The aim is to improve understanding, information sharing and cooperative planning to manage or protect heritage resources across the region. And the policy also gives direction to local government, district councils. In the context of the Waikato district, there is a legacy of historic heritage items that reflect the lives, the work of former residents, events and industries. These items and sites provide a valuable link to the past for both present and future generations. It is important that these heritage items are protected so the community can understand its past while looking to the future. Waikato District Council provides the protection and management of the district's historic heritage through the relevant provisions of the operative district plan, and since notification, also the historical heritage provisions under the proposed district plan in accordance with section 86F of the Resource Management Act, be it that they have immediate effect at notification. One component of the district plan review was a review of the Operative District Plan's historic heritage and notable tree provisions, as well as consideration of a full refresh of the items protected. Council employed external expertise to understand those reviews, to undertake those reviews. The key difference between the Operative District Plan and the proposed District Plan are the changes to the scheduling of items to be protected. The proposed District Plan, as notified, does not articulate how historic heritage and notable trees have been determined to be of value for scheduling, and lacks direction for plan users to determine whether such values remain or should be retained as part of a resource consent process. However, the structure of the rule framework proposed in the proposed District Plan aligns with that in the Operative District Plan. For instance, the use of the A and B ranking system for historical heritage, the use of the STEM scoring method for notable trees, and how ranking is applied and the suite of provisions anchored in the individual zone chapters. Under the proposed District Plan, the district's significant historic heritage and notable trees are protected through the policy framework in Chapter 7, Historical Heritage, Appendix 3, Design Guides, Schedule 30.1 Historic Heritage Items, and Schedule 30.2 Notable Trees, and specific provisions to protect identified heritage items, sites, and notable trees in each of the following chapters. I think with your approval, we can take those as read.
Yes, thank you.
Paragraph 25. In each of these zones, the provisions relating to demolition, relocation and removal, maintenance and repair, alterations and additions, site development and subdivision, with the exception of the reserve zone where there is no subdivision provisions for historical heritage items is applied, and removal or destruction, trimming and activities within the drip line of notable trees being applied are identical. Noting also that in the residential zone, there are additional provisions relating to heritage precincts and battlefield view shafts. The overview of the submissions and main themes. Paragraph 27. 326 submission points and 97 further submission points were received on the topic of historical heritage and notable trees. These were, there were three key themes from the submissions. First one, objectives, policies and rules for built heritage and notable trees. Secondly, the reinstatement and introduction of heritage precincts. And thirdly, amendments to both Schedule 30.1 heritage items and Schedule 30.2 notable trees. Heritage New Zealand and Waikato District Council made substantial number of submissions on these topics. Both submitters sought amendments to the objectives, policies, rules, methods of scheduling, definitions, and the inclusion of items. Waikato District Council submission has been broad to be, beg your pardon, Waikato District Council submissions have been broad to enable the correction of inaccuracies in both the structure and content of the schedules, and to ensure alignment of both text for historic heritage and notable tree rules in each zone, and these inaccuracies being identified post-notification of the proposed district plan. Heritage New Zealand have sought a suite of amendments to ensure a stronger heritage focus. A number of submission points sought the protection of notable trees through a blanket approach rather than via individual trees. And the recommendations relating to ranking and map notations will, if accepted by the hearings panel, require further work to finalise the ranking of those heritage items and to correct planning maps in terms of notations. Summary of recommended amendments. Historic heritage, paragraph 33. There are no substantial amendments proposed to the historic heritage objective and policies as notified. The amendments I have recommended do not alter the fundamental direction of the protection of heritage in the district. The amendments I recommend to the zone provisions ensure best practice is applied in the ability to both protect and use heritage items and sites. They correlate with the amendments sought by Waikato District Council to ensure the rules for historic heritage under each zone have the same text, and the amendments sought by Heritage New Zealand in terms of stronger heritage focus. My recommended changes also ensure alignment between the definition of activities managed through the historic heritage provisions under each zone to avoid confusion as to when an activity should cascade upon non-compliance with a standard. For instance, under the operative district plan and the notified version of the proposed district plan, maintenance and repair is permitted unless unless it affects features, and then that cascades to a restricted discretionary activity. The same occurs for additions and alteration provision as well. However, in my opinion, there should be clear distinctions between what should be deemed maintenance and repair versus additions and alterations, and then versus demolition and relocation. And the cascade should be from one of those activities to another. Through the submissions from both Waikato District Council and Heritage New Zealand, I recommended amendments to enable that clear separation and cascade of the activities that occur to a heritage item and how that should be sustainably managed. The next 4 bullet points identify that cascade. So the recommendations for the rules identify maintenance and repair being a permitted activity and reliance being on the definition proposed. Do you want me, Mr. Chair, do you want me to read those bullet points out or take them as read?
I'm not sure that everybody's got a copy of your written material, so I think it would be helpful if you read them out, please.
Certainly. Okay, permitted activity, maintenance and repair. So if replacement materials are the same as or similar to the original in terms of colour, texture, form and design to the original that it replaces, it's a permitted activity. And this correlates, as I said, with the definition proposed for maintenance and repair. A restricted discretionary activity would be alterations and additions to a heritage item. The determination of what constitutes an alteration or addition versus maintenance and repair lies with the definitions for these different activities, and also the consideration of the effects that occur when heritage items experience alterations or additions to them. Move through to demolition. Demolition is discretionary activity for B-ranked buildings and non-complying for A-ranked buildings. Paragraph 36. In addition to these rules, the purpose, I'll start that again. In addition to these rules, the purpose of the site development rule in each zone chapter is to manage the effects of works proposed to be undertaken within the setting of a scheduled item. It's important to ensure development within the setting of a scheduled item does not impact on the item's heritage values. This rule is applied in the Waikato section of the Operative District Plan and was replicated in the notified version of the proposed district plan. As written, this rule is reliant on understanding what is meant by development. The notified structure of this rule relies on arbitrary controls, for instance, retaining a separation distance of 10 metres from a scheduled item. As I stated in my Section 42A report, because development is not defined in the plan and the existing conditions cannot be justified, the extent of what is considered development as a permitted activity needs to be expressed in the rule, and then that then can cascade if those conditions are exceeded. I consider the recommended amendments to the provisions briefly addressed above will provide greater guidance for plan users on the management of scheduled items and enabling the continued use and adaptive reuse of that resource. Under the proposed district plan, Schedule 30.1 is a table listing the individual heritage items and implies only certain features are protected. There is no guidance on what the historic heritage ranking means, how to apply an assessment of the heritage values afforded to those items, and to understand why items have been scheduled. To improve this, I have recommended applying an explanation of the differences between the A and B ranking for historic heritage and the criteria set out in the regional policy statement and utilised by Dr. McEwen as part of her assessments that have formed the heritage reports for each scheduled item. To ensure best practice is applied in the protection of historic heritage, I have recommended removing any reference to specific features, with reliance being placed on the information within each individual heritage record instead. The heritage records prepared by Dr. McEwen in determining whether an item should be scheduled and the ranking to be applied set out the heritage value, reasons for an item's protection, and the extent of its setting. This information is of great assistance to holistically consider the proposed actions to a heritage item. The present format of the proposed district plan removes that holistic approach and renders the heritage item's importance to the protection of only certain features, meaning there is a higher potential for the overall heritage value of an item to be lost. This is not best practice. The determination of scheduling individual items has been reliant on the expert advice from Dr. McEwen. Dr. McEwen will expand on the approach she took in reviewing the operative district plan schedule, the historic heritage resources the district has, and her opinion on recommendations. A number of submitters sought either the reinstatement or addition of certain buildings and structures onto the Schedule 30.1. All of these requests were assessed, that should read, by Dr. McEwen, and 13 additional items were recommended to be added to the schedule. I wish to highlight to the panel at this point that 5 of those items recommended for scheduling were not considered by Dr. McEwen to warrant protection. As I state in my Section 42A report, while it is not normal to go against the advice of the expert, in these cases, the opportunity to provide heritage protection is, in this case, being the district plan review, the opportunity to provide heritage protection is not readily available. So I have taken a more conservative approach to recommend protection. As once removed from the schedule, there is no statutory protection afforded these items, and they could be lost. The 5 items being 14 Galileo Street, Ngarawahia, numbers 11 and 19 Bow Street, Raglan, the Whotawhata Cemetery New Zealand War Memorial, and the Ngarawahia New Zealand War Memorial. No changes have been made to the planning provisions relating to heritage precincts. As a result of the submissions sought the reinstatement of the heritage precinct over Rangiriri as it is under the operative district plan, and sought a new precinct at Raglan. I now move to notable trees, paragraph 45. There are no amendments proposed to the notable tree objective and policies as notified. The amendments I have recommended to the zone provisions for the removal, destruction, trimming and works within the drip line of notable trees are to ensure best practice is applied and to ensure there is consistency in the text of these rules under each zone. Under the proposed district plan, there is presently no explanation of guidance on how the trees have been assessed for protection or what should be used to assess proposals that could affect the notable tree. To improve this, I have recommended, in addressing the submissions by Federated Farmers New Zealand, the introduction of a section at the start of the schedule to explain the type of assessment used, being the STEM method. The Waikato District Council submissions seek amendments to Schedule 30.2, notable trees, to correct duplications, editorial errors, and improve the accuracy of the information provided in the schedule. Now, since the release of the 42A report in June, Council's arborists have further reviewed the information contained in the schedule, that being the notified version and the one anchored in the recommendations. As a result of this work, I have been advised that it would be their preference to undertake further wholesale technical review of the schedule as recommended, recommended in the 42A report, to ensure that there is a complete removal of any potential inaccuracies that may still exist, and that there can be total confidence in that information. The detail of this further work will be addressed by Mr. Searle and Mr. Gordon. Now move on to matters of contention raised in submitted evidence. Paragraph 49. I have considered the evidence provided by the following submitters on the following matters and advised that nothing has caused me to change my recommendations set out in the 42A report. First is the scheduling of heritage items. The Ministry of Education has seek the removal of 3 school buildings from Harrisville School Teachers House, the Tamahiri School Building, and the Tamata School Building from Schedule 30.1. I continue to support my original approach that these items should be scheduled and not removed from the schedule. Heritage New Zealand have sought the Otago Memorial Bowling Club grounds, gates, and associated boundary wall, beg your pardon, to be added to the schedule. Dr. McEwen advised the gates and associated boundary wall warranted scheduling, but not the actual greens. This remains the recommendation. With regards to earthquake and fire safety provisions, Ms. Carolyn McKelly, on behalf of Heritage New Zealand, filed evidence seeking the inclusion of specific earthquake and fire safety provisions. I continue to support my original approach that fire safety and earthquake strengthening works can be adequately addressed under the umbrella of the policy and rule framework for additions and alterations. Ms. Christine Madsen and Ms. Carolyn McKelly also filed evidence seeking the Heritage Precinct at Rangiriri. As outlined in my rebuttal, I stated Council's heritage expert, Dr. Anne McEwen, has advised that the existence of these 2 heritage items does not constitute the basis to apply a heritage precinct over the area. So there are 2 heritage items that are scheduled at Rangiriri. I am not persuaded by points raised by Ms. Marsden that it is necessary to have a special zone to protect the area, and that the establishment of a heritage precinct will stimulate interest in the settlement and its history. I consider the suggestion by Ms. McKelly that Council consider alternative management mechanisms may actually support the outcomes being sought by Ms. Madsden. Such mechanisms, however, are outside the scope of the district process, in my opinion. So in conclusion, the forefront of my consideration of the submissions relating to historic heritage and notable trees was the balance of the protection and the sustainability of the resource, either the actual building, tree, or the site of the protected item. The recommended amendments to the proposed district plan apply best practice for protection of historic heritage and notable trees, achieves the directions for the protection of historic heritage under the regional policy statement, and provides the framework to enable the change of use and encourage the continued use of scheduled items. I consider the recommendations I have made to address the relief sought through submissions on the historic heritage and notable trees matter efficiently and effectively achieve the purpose of the Resource Management Act. Thank you.
Thank you, Ms. Morris.
Now, Chair, both the experts, Dr. McEwen and Mr. Searle and Mr. Gordon, both have brief opening statements as well. I'll pass on to Dr. McEwen now.
Yes, thank you. Morning, Dr. McEwen.
Morena, kia ora koutou. I will read all of my statement just for the benefit of the submitters, if that's all right. I'm a heritage consultant with over 30 years experience in this field. I hold a PhD in architectural history from the University of Canterbury. I'm an experienced peer reviewer and expert witness and a full member of ICMOS New Zealand. I've undertaken the review of the built heritage schedules for the Thames Coromandel, Waikato, Nelson, Waimakariri, Selwyn and Timaru district plans. I started work on the Waikato District Council built heritage schedule in February 2016. The bulk of the heritage assessments that I undertook for Waikato District Council were completed by May 2017. The review of the heritage schedule was predicated upon the preparation of a thematic historic overview of the district, which is best practice these days, and encompassed both the heritage schedules in the Franklin and Waikato operative plans, and also considered potential new heritage items arising from both nominations and the identification of further items based upon the historic overview. I devised the historic heritage item record form for use by Waikato District Council in respect of the assessment criteria that are in the regional policy statement. I also developed the assessment methodology for ranking highly significant and significant heritage items, and that drew upon the methodology developed by Christchurch City Council, for which I was an expert witness in its replacement plan a couple of years ago. And I'm familiar with the Code of Conduct, and I have no conflicts of interest in regard to the historic heritage of the district. I attended a report to Ms. Morris outlining my response to the submissions and further submissions received by the Council in April of this year. And I also presented a report with regard to the former St. Paul's Methodist Church, which was a submission point from Hamilton City Council, and I presented that to Ms. Connolly in February of this year, given that Ms. Morris has an association with Hamilton City Council. My primary focus in both reports was the items included in Schedule 30.1 of the notified plan. In addition to responding to the submissions and further submissions relating to Schedule 30.1, I also provided information and advice to Ms. Morris on other matters, including the identification of heritage settings and the way in which the schedule review had been undertaken. In response to submissions and further submissions, I met with Heritage New Zealand Poheri Taonga staff and also made a site visit to Clunes, the house at Onawhero, at the invitation of Brendan. What a lovely outing, thank you, Brendan. As noted in my report dated 10 April 2020, I did not format Schedule 30.1, and nor did I supply much of the information contained within the physical description and significant features column. Ms. Morris has recommended a revised format that will conform to best practice and provide clear and concise information for property owners, consenting planners and others. It is recommended that the historic heritage item record form for each scheduled item, which I prepared, is linked to the e-plan at Schedule 30.1, as is becoming the standard approach for plans around the country. As is generally the case, submissions in regard to Schedule 30.1 were largely concerned with inclusion or exclusion from the schedule. In some cases, the submitter appeared to be concerned about the implications of scheduling rather than the scheduling per se. And I give the example of a submission from D. Bond 946.1. While it is acknowledged that scheduling imposes some limitations on the owner of a heritage building or structure if they wish to demolish or make substantial alterations and additions to it, There are also incentives available at both the local and national level to help meet the costs of maintenance and, for example, seismic strengthening from the central government's Heritage Equip Fund. It is quite common in my experience that submitters may oppose the scheduling of their property, not because they deny its heritage significance, but because they are unsure as to what that will mean in a practical sense during the life of the district plan. In some instances, the difference of opinion between myself and submitters hinges upon the distinction between historic heritage significance and character amenity value. And this applies, for example, to submissions received about 19 Bow Street in Raglan. Although the RMA does not use the word significant, it is accepted best practice that historic heritage resources must demonstrate a level of significance sufficient to merit scheduling on a district plan. Character buildings, such as those at 11 and 19 Bow Street in Raglan and 14 Galileo Street in Ngaruawahia, for example, do not warrant inclusion in Schedule 30.1, in my opinion, because they do not meet the criteria for heritage significance. In order for the heritage schedule as a whole to be robust, defensible, and consistent, it is important, in my view, that character buildings are not scheduled and thus subject to the objectives, policies, and rules intended to protect historic heritage resources. Several submitters requested that buildings excluded from Schedule 30.1 be reinstated if they are currently scheduled in the operative plan or added to it. In the case of the Heritage New Zealand submission, a number of items were proposed for consideration based upon a World War I and other wars research project undertaken by Heritage New Zealand in 2015. All such submissions were carefully reviewed, and any new or additional information provided by the submitter was considered in light of the assessment criteria. My recommendations are included in the Section 42A report. Several of the Heritage New Zealand proposals, for example, the Kariotahi Hall, had already been recommended for scheduling, whilst others, the Whitikahu Hall and Memorial Gates, for example, have now been recommended for addition. There remain 5 items in contention between me and Ms Morris in her Section 42A report, which Ms Morris has already itemised: the Bow Street buildings, the house across the road in Galileo Street, and 2 Waikato Wars memorials. While I consider Ms Morris's conservative approach to recommending scheduling of these items is a reasonable one, I have not changed my opinion that there is insufficient evidence to support inclusion of any of those items in Schedule 30.1. A number of submissions and further submissions were made in regard to the identification of heritage areas and their management by way of design guidance. If they are to be protected under Section 6F of the RMA, such areas need to meet the same criteria for scheduling as an individual building or structure. In the case of Rangariri, there is insufficient evidence, in my opinion, to support a heritage area or precinct. Hence my recommendation that a village design guide be developed in future. So to conclude, I reviewed all assessments where the submitter provided additional information and stand by my revised assessments and the rankings of each item. I considered that the schedule I recommended to Waikato District Council was robust and consistent, and note that the peer review report provided to Council by Archifact Limited, which is dated June 2018, affirmed the sufficiency of the heritage item reports to support scheduling and item ranking within the proposed district plan. Thank you.
Thank you, Dr. McKeown.
Chair, we will just swap. We'll just move now to the arborists.
Thank you.
Here we are.
Ms Morris, just to clarify, I didn't want to interrupt you at the very start. You mentioned that your written summary had been forwarded. I've checked with the secretary and no one has seen that in advance of the hearing. So what I'm going to ask you to do is to, if you haven't already, if you can make that available to council staff so that they can forward that to us for our records. I mean, we listened to what you've said and we're not disadvantaged by that, but we haven't seen that, and it would be helpful to us for us to have it. Thank you.
I was unaware of that. So you won't have seen either.
You haven't seen any of the statements that have been read out this morning.
Right, we will sort that out for you.
Thank you.
My apologies.
Morning, Mr. Chair, Commissioners and Submitters. I will read all my summary as you haven't received a copy of it. My full name is Grant Leonard Searle, and my colleague at my side is Robert Gordon. Kevin and I are employees of Waikato District Council in the capacity of being a former and existing district arborist. Have assisted with the district plan review of notable trees within the bounds of the Waikato District Council. The purpose of the notable tree review was to re-evaluate trees listed in the operative Waikato District Plan, being the Waikato Section F notable trees and the Franklin Appendix 2 of the inventory of the historic buildings, structures, trees and areas, Group C trees, and to evaluate additional trees nominated for inclusion as notable trees. Qualifications and experience. Kevin Gordon.
We can take those as read, thank you. They're in the Section 42A report. And, you don't need to spell all your qualifications out. Thanks.
Thank you, Mr. Chair. I'll take that. Point 3, assessment criteria. For the purpose of this summary and to avoid repetition, as alluded to in Section 42A report by Alice Morris, the method adopted to evaluate all trees is a standard tree evaluation method, commonly known as STEM. The STEM evaluation method is a widely used and is an accepted tree evaluation method that provides consistency with objective criteria and assessment definitions. Tree assessment is a subjective topic, but the STEM assessment method is transparent, it's specific, and with little scope of creative interpretation. The main sections of STEM are subdivided into the following categories: condition, amenity, and notability. Those categories are then broken down into further criteria that can be separately valued to a maximum perfect score of 30 points. And I'll just say there is no such tree with a perfect score. Please refer to the attached copy of an evaluation score sheet, which you would not have received, but we can provide that if requested. The threshold for determining a tree for inclusion in the notable tree list is set at 160 points. Point 4, tree assessments. Trees listed in the respective Waikato District Plan, Operative District Plan and Franklin Section notable tree registers were re-evaluated. Note that several trees listed in the operative plan could not be located, and in one case, a notable tree had been felled. Approximately 20 new trees were nominated for assessment. Section 5, Schedule 30.2 notable trees. Schedule 30.2 notable trees details those individual trees and groups of trees that meet the thresholds to be recommended as a notable tree. I must acknowledge some anomalies in that schedule. Specifically to properly address where since the original evaluation of a specific tree or group of trees was undertaken, the site has been subject to a subdivision. The subsequent creation of an additional lot on a parcel of land has resulted in a tree potentially now being listed on an incorrect property number. To avoid the need of a variation, has requested time be permitted to undertake an additional technical review of the accuracies of the schedule. Point 6, definitions. The tree protection zone, known as TPZ. The definition of a drip line for a tree is determined by the extremities of the branch tip ends, canopy spread. For a tree species with a conical fastigiate upright habit, example, a Lombardy poplar, the canopy spread is very compact and branches are nearly erect. To minimise potential adverse effects on a notable tree as a consequence of any type of earthworks or activities, the calculation of a tree protection zone is recommended. For a broad spreading tree species, the canopy drip line is used as point of measurement to define the tree protection zone. For an upright fastigiate tree species, the method to calculate the TPZ is measuring the stem, the trunk, diameter at breast height, which is approximately 1.4 metres above ground level, and multiply that by 12. So it's TPZ, tree diameter at breast height, times 12. In addition to the diagram on page 27, section 42A hearing report, an additional diagram for clarity purposes showing a fastigiate tree species should be included. Applying the tree protection zone will provide greater clarity and ensure improved plan administration. Therefore, it is recommended the definition for the drip line be modified as proposed. Thank you, Mr. Chair. That's my summary.
Thank you, Mr. Sell. Does that mean we're going to hear from Ms. Connolly on her addendum report regarding the relocation of the church? What's the next step from the council's presentation?
We were actually going to say that that was our presentation, but if the panel would like to hear from Ms. Connolly, she is available.
I can see her there. I think for the record, we would like just to have the recommendation recorded. I think, please, Ms. Connolly, if you're able to do that for us.
Oh.
Oh, you've changed screens. Thanks, Ms. Connolly. You don't need to go into it in any great detail, but I'd just like you for the record to record your conclusions, please.
Okay, I will have this loaded and sent to you, Mr. Chair. The scope of the addendum, preparation of the Section 42A report. The scope of the addendum of the Section 42A report was to evaluate the submission and further submission received in relation to the inclusion of Schedule 30.1 historic heritage items of the former St Paul's Church. In preparing this addendum and for technical matters, I rely on expert advice from Dr. Anne McEwen, Heritage Consultancy Services. I refer to evidence from Miss McKelly on behalf of Heritage New Zealand in response to further submission 1323.143, in which Ms. McKelly confers with the recommendation as stated in the addendum. Therefore, my recommendation stands as reported. Short and simple.
Thank you, Ms. Connolly. That's helpful. All right, let's see if the panel have some questions. I know I do. So maybe we'll start with you, Ms. Tiaho, please.
I don't have any questions yet. I'd like to hear from the submitters, and then I might have some questions after that, if that's all right.
Okay. Thank you. Mr. Marg?
Not at this point, Mr. Chair.
Ms. Gibb?
No, same. I'd rather wait till the submitters have presented. Thank you.
All right. Well, I've got quite a few, and I think I will pose most of them now. If it makes more sense to wait to hear from some of the submitters to form a final view on them, that's fine. But I'm just trying to see if I can. Mr. Bell, can you allow me to share my screen, please? Because I want to refer to the Section 42A report. I think it's probably easier if we're looking at the text as we talk about it. Thank you. So if someone in the room could just let me know when that screen is showing up. Can you see?
Yep, we can
you can
see
see that now? Okay, I've only put that there so because I'm going to refer to a number of paragraphs and a number of written provisions, and I think it's a lot more straightforward if people can read that. Some of these are reasonably pedantic, but we're very keen to make sure that there's no ambiguity in whatever it is that's written in this plan in whatever form it might finally take. So, so we're going to take a bit of time to explore that where we need to. In terms of this redlining that you can see where my cursor is, which is the introduction to the rules section, and I think this is probably best asked of you, Ms. Morris, but if Dr. McEwen is better placed to answer it, that's fine. It just strikes me when it says Heritage New Zealand must be contacted regarding development on or in proximity to these sites. I mean, I'm not sure that that's strictly correct. And there's no obligation to contact anybody. There is an obligation to obtain the necessary approvals from Heritage New Zealand. But do you agree that the wording there is actually sort of factually incorrect, or at worst, or at best ambiguous?
I'm sorry, Chair, the page that you're showing on the screen, I don't think is the correct page. What page are you referencing?
I'm referencing page 18. Is that not showing?
We can see page 2 of 7 with green highlighted background text.
Which is actually the...
Oh, I'm sorry. I'm on that's the heritage provisions for Matangi that I was going to ask you about shortly. I must have shared the wrong screen. Sorry, let me start again. That's very unusual.
So you're talking
about...
about...
I see what I've done. Sorry, that's my error. I'm sorry. How does that go?
Yes.
Sorry.
Okay, so no, that is factually correct because when we're talking about archaeological sites.
In proximity to? Well, and what does in proximity to mean? Next door?
Is the ability to take enforcement action on that person.
I understand that, but that's not the same as saying that if you're down the road from a heritage site, you must contact Heritage New Zealand. You must ensure that you have any authority before you destroy anything, but that's not what that provision says. It says Heritage New Zealand must be contacted regarding development in proximity to scheduled sites. And I don't think that's correct.
So that wording is taken from Heritage New Zealand directly from their submission.
Yeah, I'm aware of that.
Rephrased it slightly, and they have, in terms of the rebuttal, the evidence in my rebuttal, there's just been, acknowledgement of that. Those sites are unrecorded or recorded, so that's the proximity word. That's why I've used that. I understand that there could be, the difficulty of what is in proximity, but I feel that it is guidance for the district's landowners and developers, being in the district plan in chapter 12. The word must could be a bit hard for a guidance note, but it is trying to stress that they do need to have a conversation with Heritage New Zealand on these matters.
I'll think I'll leave it there. Is the purpose of that advice note to also note, because it seems to me to be unclear, isn't it saying two things? Isn't it also saying that the district plan may well not be complete and in fact can never be complete, and there's a second database that relates to the Heritage New Zealand archaeological sites records? Is that part of what that is trying to say?
Well, no, it's not trying to say that.
Should it?
Well, I mean, the district plan does not capture all archaeological sites.
No, I know that, but it said the first sentence says the district plan identifies heritage items and then full stop. Shouldn't it clarify the situation to actually say that there's a link between those two provisions? Because someone can't rely on the district plan to be clear that they're not interfering with archaeological matters of interest.
Well, I think you've got the first sentence, the district plan identifies heritage items, comma, notable trees and Maori sites and areas of significance on the planning maps, full stop.
Yes.
Archaeological sites, both recorded, identified by the NZAA Archaeological Association, and unrecorded are protected under the Heritage New Zealand Paetanga Act. So for me, that sentence clearly identifies that there may be sites that are not scheduled.
But in the interest of making sure that people know what it says, shouldn't we make it clear? Because it's not clear to me, I have to say. I mean, you're right if you're an expert and you actually know what these two acts do, but if this is an introduction to someone that's not sure if they can dig a ditch on their farmland or something, I'm not convinced that they're going to actually know the subtlety of what it is that says. And I don't think we want to have to rely on someone ringing up Heritage New Zealand to get clarity on what that means, or contact the district council. So I don't want to get into a debate, but you would accept the point that I'm making, that the intention of that is partially to record that there are these two separate provisions, and the district plan, just because something's not scheduled in the district plan, doesn't mean to say that it may not have, a property may not have archaeological significance and so forth.
That's correct.
Okay, that's fine. Thank you. That's cool.
Yes.
Thank you. Can I just take you to, and this is probably more for the for Mr. Searle or Mr. Garden. It's this definition relating to drip lines of tree.
Yes.
It just seems odd to me that the definition of a drip line relates to something that's got another definition. It means the ground beneath the foliage of a tree area surrounding a tree, known as the tree protection zone. But that's not really the drip line. I mean, in common parlance, the drip line is the drip line, isn't it? It's where the canopy extends to. And I just wonder if, again, there might be too much technical jargon in this definition to make it readily understood by people.
So the submission talked about the existing definition not being clear when you were talking about a deciduous tree.
Yes.
So in researching, the talking, I should say, with the arborists, and I will get Kevin and Grant to do the technical conversation with you. But the shape of the tree, as stated by Grant earlier this morning, does actually come into play. And so in terms of the technical stuff, we're trying to align that with good arboricultural practice.
Okay, no, that's fine. I don't think I need to get that clarification. We'll see it when the revised drawing comes in. That will be helpful. Can I just ask though, is it intended that there's two, it says in the definition, and I've gone back a page, the extent, it's or the formula or the extent of the canopy spread. Is it intended to be the greater of those two, or can you pick and choose which one applies?
I'll just turn you to Grant. Sorry.
Just to clarify, Mr. Chair, the formula is applicable to fastigiate tree species only. So the canopy spread is relevant to broad spreading growing species, tree species.
Right. Okay.
Okay, so is that clarified?
Okay, so that wasn't altogether clear, but it is now that you've explained it. So that's fine. Thank you.
Yes, that's why we're sort of putting two diagrams in there. So we've got one for the broad spreading and one for the fastigiate trees.
Okay, I didn't quite follow that either. I thought there was a replacement, but that's okay. That's helpful.
Thank you.
Getting on to perhaps now more substantive matters, because I don't want to spend too much time just on words. If we go to paragraph 143, which is the recommended amendments to policy 7.1.2, which is about the identification of heritage items. I suppose the first question is where it says where the values may include, and there's a list. that implies that that's a non-inclusive list and there may be something else that applies. And when you look at the schedule, it uses those same general terms. So I guess the question is having a non-inclusive list there appropriate?
I think it's actually the use of the word may. It should be an inclusive list in terms of the criteria. So
okay,
taking the word may out.
Okay, thank you. That's helpful. The second point is, and I just wonder if we go forward now to the next policy in this, which is the policy 7.1.3. I'm sorry to move around all over the place, but it is set out there, and it has that same may include under 7.1.3b. It seems to me that 7.1.2, the one that we were just talking about, which simply says we need to schedule trees having regard to these factors, whether in the interests of clarity, policy 7.1.2 is actually redundant, provided that 7.1.3b refers to scheduling of, to incorporating the two together, if that makes sense.
Mr. Chair, I did consider that and consider the potential for repetition. However, I did feel that both 7.1.2.
I'll just go back to that, shall I?
Yes,
there
sorry.
It is.
7.1.2 is identification, and those matters, those values are key to the identification and scheduling.
Yes.
But then they are also matters that need to be considered when looking at heritage items and the protection of those items. So it's a reiteration of ensuring that when a resource consent comes in, there is no misunderstanding that those values fall away at the point of identification, and then you don't have to worry about them when you're protecting the scheduled heritage items. So hence I've left them in there.
All right, that's okay. That's fine. I understand the logic. Can I take you to going back to policy 7.1.2 and getting, whoops, paragraph 179. Sorry if everyone's going dizzy from the screen maneuvering. I just want to ask you a couple of questions about what this means. So if we look at clause C of policy 7.1.3 it is, I'm sorry, not 7.1.2. I've written it down wrong. Firstly, should in C, when it says relationship between heritage buildings, site structures, places and their settings, I understand that part, including the view of the heritage item are retained. That seems pretty broad, you know, in the sense that, you know, where are those views from? Are they from public spaces? Are they all views? Because it seems to me that that's got the potential to actually say, to have quite far-reaching effects that may go beyond what the intention of that policy is.
Oh, I totally agree, but I wasn't able to correlate a submission to remove that last part of that sentence. My opinion, it should stop at setting. But
okay, we're taking a fairly broad view of submissions, and if we can find one that's broadly on the theme and something needs to be fixed, we're inclined to fix it. If you take my point. So we're happy to get that recommendation, and we can have a look and see whether there's a submission that we can shoehorn that point into. Dr. McEwen, was there something that you wanted to say about that?
My feeling is that it bears upon the 10 metres from the road provision, which I think was Waikato District Council.
Yes, yes, and we have proposed, the recommendation is to remove that in terms of the rules relating to site development. So that might be the hook.
It might be a consequential to that. Okay, I just want to get your technical view or your technical views from the two of you on some of these. That's why I'm asking. In E, I'm just intrigued as to how you can protect. I can see how you can protect something from being demolished or removed. Well, I'm not even sure about the latter, but what does it mean by protecting scheduled items from relocation? Do you mean, because I can see you can prevent it, but protect it from relocation seems to me to not be a logical choice of words.
I mean, yes, I can see your point there as well. I mean, in terms of E, it is to identify that demolition, relocation and removal shouldn't easily occur to a scheduled heritage item. Relocation is probably seen as the
option of last resort.
Exactly, thank you very much. But you should protect your scheduled items from any of those three actions. So maybe.
But aren't they in a hierarchy though, and for the reasons that you've said?
Yes, and maybe that is that we would have the ability to refine that policy further. In terms of how they're listed there at the moment, that's how it's stated in the rules. So I've just followed the format of the plan in that sense.
Right, and I also wonder too, aren't the caveats on that actually important? Because it's not just changing the semantics of the policy. Protecting scheduled items from demolition, relocation or removal is fairly directive. You know, it basically says you can't do it or you can't readily do it, and it's something to be discouraged in all but pretty, extreme circumstances. But aren't those caveats when they're a serious risk to human life, and all those sorts of things? Isn't it important to have that exemption clearly set out, mirroring the language in Section 6 relating to inappropriateness caveats?
Well, I don't feel that those caveats should be anchored into the policy framework, because the activity status for demolition, relocation or removal is either a discretionary activity or a non-complying activity. So the specifics of each site can be assessed through a resource consent process. So the reasons for relocation, demolition or removal, be it serious risk to human health or it's no longer economically viable, would be those matters that would be considered at that time. I feel if you anchor it into a policy, it becomes the immediate rationale for achieving that policy.
I understand that, and that's a very fair point. But how do you get anybody to be able to consider those factors in a non-complying or discretionary activity, bearing in mind that discretionary is not, the be-all and end-all of activity statuses? It's sort of generally seen as potentially appropriate, subject to conditions and so forth. How would someone say, in terms of the policy framework, to say actually this building's really unsafe and there's nothing practically I can really do about fixing it? The policy says you've still got to protect it. So you'd be contrary to that before you started.
That is true, but then you would rely on the effects. So you would have a suite, an applicant would have to set out the suite of effects of not demolishing or removing or relocating
but it's the adverse effects that have to be considered, and the adverse effects would be the effects on the heritage value, not weighing up the benefits of safety against the negative effects of collapse. collapse or injury to health. So I think you've created, I would have thought that you're creating a policy framework that says if you've got a building that's inherently unsafe, 10% of code or 5% of code and essentially falling down, I'm not sure how you could ever get consent for a non-complying activity because of the thresholds that would apply. And I don't know if that's necessary. I totally get the point that you're not wanting to make an easy option to say, oh, well, we've tried a bit and it's all too hard, so we're going to demolish it, using the caveat. But I just wonder whether you've created a problem by moving that line too far the other way.
Well, I think possibly for discretionary. However, I mean, an A-ranked building is seen as significant for the district. So, being non-complying, it's the policy direction should more or less align with try everything you can to keep that building there.
But it doesn't say that. I guess, and I agree with that, but it doesn't say that. It just says protect it from demolition. And if you're saying protect it from demolition, you're effectively saying that in a policy sense, that's a prohibition, unless you've got the ability to say there are exceptional circumstances relating to safety or something else. And I don't quite see how you can take all the caveats away and still have a non-complying activity rule. One, because you'd never pass the threshold, because I'm pretty sure you'd say it's not being protected. So you're contrary to the policy. The effects on heritage by knocking the building down would not be less than, or would not be no more than minor, but almost by definition, because they're in the schedule. End of story. And then you're left with a completely unsafe building with no ability to remove it. And I mean, Dr. McEwen will remember the conversations that the panel had in Christchurch around some of those issues. I'm certainly not advocating that we provide a get out of jail card for people with rank A heritage buildings, but where something is inherently unsafe and can't be fixed, surely the policy framework has to acknowledge the possibility there.
Well, I think that there is case law that does take all those matters on board, and I mean, in terms of looking at the sustainable use of that resource, the economics and safety come into it. So I take your point in the language of the word protect. We,
Maybe have a think about it, but I don't want you to to try and draft things on the hoof.
On the hoof, yeah, I appreciate that.
But I am very keen to make sure that we don't have to rely on it. If one of these circumstances arose, someone would have to rely on a case from somewhere else that said, well, if the district plan wasn't written clearly enough, it's clearly not the intention for that to happen. Well, if that's the case, we should sort of address it proactively and fix it up, it seems to me. I'm just mindful of the fact, I know we're running a little bit behind schedule and I haven't finished yet. I've got a few more I want to ask you about. Because we've got other people joining the other meeting at 1:45, and so that they're not left stranded and wondering what's going on, I think what we might do is take our 15-minute break now and then come back at 1:45 on the new code, and we'll just carry on where we are. We'll do a brief introduction to the people that are joining that session, and then we'll carry on and conclude my questions, which won't take very long, but which we can do at the front end of the next session, because I think we'll move through things reasonably quickly from then on. Is everyone happy with that?
Yes, thank you. Happy on this side.
Sorry, Mr. Wood, you might have to wait around a little longer than you might have otherwise anticipated. Hopefully that doesn't cause you any hardship.
That's fine, thank you.
All right, thanks everyone. So if you could log out of this call, the panel could just wait for a moment, but if everyone else can log off, we'll resume at 1:45. 11. Thanks.